We're at the fork in the road. Should we push for an Article 5 convention, or should we do what our framers advised when the federal government usurps power? Alexander Hamilton warned that most men who overturned the liberties of republics began by paying obsequious court to the people, commencing demagogues and ending tyrants. That is happening today. False friends, demagogues, are demanding a convention where they claim they can improve this Constitution by amendments, while they actually scheme to increase government power over us by rewriting our Constitution. Meanwhile, George Soros and his gang of Marxists want a Marxist Constitution in place by the year 2020. Before these change agents on the left and the phony right can get a new Constitution, they need a convention, because a new Constitution can only be introduced at a convention. False friends are not being truthful, but I will show you the truth. Article 5 provides two methods of amending our Constitution. Congress proposes amendments or calls a convention to propose amendments if 34 states apply for it. The first method was used for our existing 27 amendments. Congress proposed them all. Under the second method, Congress calls a convention. We have never had a convention under Article 5 for good reason, as you will see. Let's look at the 5,000-year miracle we are in danger of losing. When we ratified this Constitution, we created the federal government. It is a federation of sovereign states united under a national government only for those limited purposes itemized in the Constitution, with all other powers reserved by the states or the people. We listed every power we delegated to the federal government. Most of the powers delegated to the federal government over the country at large are listed at Article 1, Section 8, Clauses 1 through 16 on this one little page. All our Constitution authorizes the federal government to do over the country at large falls into four categories: military defense, international commerce and relations, immigration and naturalization, domestically create a uniform commercial system, weights and measures, patents and copyrights, a money system based on gold and silver, bankruptcy law, mail delivery and some road building, and with some of the amendments secure certain civil rights. That's basically it. All other powers are reserved by the states or the people. This chart, and I have them to hand out, illustrates two principles in our Declaration of Independence and shows how they were implemented in our Constitution. That rights come from God, and the purpose of government is to secure these God-given rights. In 1776, with our Declaration of Independence, we lit such a beacon as the world had never seen. And in 1787, our framers gave us a constitution with a government whose sole purpose was to secure our God-given rights to life, liberty, and property by means of exercising the handful of enumerated powers. When a government merely secures God-given rights, we are never put in conflict with each other because no one has his hand in anybody else's pocket. It is only with respect to the enumerated powers listed in the Constitution that the federal government has lawful authority. If it's on the list, Congress may make laws about it. But if it's not on the list, Congress usurps power and acts unlawfully when it interferes.
That's right.
Depending on how you count, Congress only has 18 to 21 powers over the country at large. If we followed our Constitution, most people could live their entire lives without ever having anything to do with the federal government. So why is our country becoming a totalitarian dictatorship? Because for 100 years, we, the people, and those we elected have ignored our Constitution. It was our duty to enforce our Constitution and make our public servants obey it. But we stopped reading our Declaration and Constitution, and because we didn't know what they say, we were unable to do our duty to vet, monitor, and discipline our public servants. We allowed our servants to bribe us into surrendering our liberties. That was the purpose of the unconstitutional federal government assistance programs of the early 1900s, Social Security in the 1930s, Medicare in the 1960s, to demoralize us, strip us of personal responsibility, and make us dependents, so that we would dance to the tune of our servants instead of making them dance to ours. Their tune is tyranny. Our tune is the liberty enshrined in our Declaration and Constitution. The federal government has usurped thousands of powers which aren't on the list. State governments have collaborated with the usurpations, and we, the people who ordained and established it, don't have a clue what it says about anything. We don't know that the Constitution, that Congress has lawful authority only over those 18 to 21 powers enumerated in the Constitution. We believed the lie that the feds can do whatever they want, except as limited by amendments. False friends exploit our ignorance when they tell us amendments can limit the powers of the federal government. But when people learn this short list of delegated powers, they can't be deceived by false friends who tell them that the remedy for a federal government which has seized thousands of powers not on the list is to amend the Constitution. Think. When the feds seize powers which aren't on the list, what part of our Constitution do you amend to fix that? Do we need an amendment saying the feds can't do things which aren't on the list?
I already said that.
We already did that. It's the 10th Amendment. They ignore the 10th Amendment. Even so, Mark Levin, Michael Ferris, and Rob Nadelson of the so-called Convention of States Project insist the problem is the Constitution. They say the solution is change the Constitution. Yes, even though we abandoned the Constitution 100 years ago and ever since have no standard but our own opinions, all we need to do is change the Constitution and that will fix everything. Levin and Ferris say amendments will limit the power and jurisdiction of the federal government. But our Constitution already limits the powers of the federal government to those 18 to 21 few and defined powers listed in the Constitution. So how can changing our Constitution limit the powers of the feds when they are doing thousands of things the Constitution already says they can't do? Look at guns. Our Constitution doesn't delegate to the feds power to regulate guns, gun sales, ammunition, firearms dealers, and do background checks. But they do it anyway. So let's pass an amendment saying they can't do any of this. But we already did that. It's the Second Amendment. They ignored the Second Amendment. So the claim of these false friends that we can control the feds who ignored the Constitution by changing the Constitution is so absurd they cannot possibly believe it. They have a hidden agenda in agitating for a convention, and from the absurdity of this claim and the falsity of their other claims, we may infer an evil intent. We know that Levin and Ferris don't want to limit the power of the federal government because the amendments they propose legalize powers the feds have already usurped. Let's look at three of them. Michael Ferris is pushing a parental rights amendment he says would protect parental rights, but it does the opposite. It expressly delegates power over children to the federal and state government. Section 3 of his amendment says, "Neither the United States nor any state shall infringe these rights without demonstrating that its governmental interest as applied to the person," that's the child, "is of the highest order and not otherwise served." I wrote 2 papers on this, the Parental Rights Amendment. If they're online, this amendment is viciously deceptive. Mark Levin's amendments also do the opposite of what he claims. This paper, Mark Levin's Liberty Amendments Legalizing Tyranny, shows how 6 of his amendments legalize powers the feds have already usurped. Levin's amendment to limit the federal bureaucracy legalizes what are now unconstitutional federal agencies: education, energy, agriculture, EPA, DHS, HUD, HHS, etc., etc., etc. Our Constitution doesn't authorize these agencies. They're not on the list. But Levin's amendment legalizes these agencies for as long as Congress reauthorizes them. Article 1, Section 1 of our Constitution says only Congress may make laws. But since Woodrow Wilson, federal agencies have been writing rules, the Code of Federal Regulations. All these rules are unconstitutional as outside the scope of powers delegated and is in violation of Article 1, Section 1. But Levin's amendment to limit the federal bureaucracy legalizes these rules and the rulemaking process as long as Congress approves certain of the rules. Levin's amendment to limit federal spending is also phony. Our Constitution limits Congress's spending to the enumerated powers. If you go through the Constitution and highlight all the powers delegated to Congress and to the President, you will have a complete list of the objects on which Congress is authorized to spend money. That is how our Constitution already controls spending, but they ignore it. Levin's amendment substitutes a budget for the enumerated powers and thus legalizes the current practice where Congress spends money on whatever they or the President put in the budget. And while it pretends to limit spending to revenues, it actually permits Congress to suspend the spending limit and continue to raise the national debt. The result of Levin's balanced budget amendment is to legalize spending which is now unconstitutional. It changes the constitutional standard for spending from whether the object of spending is an enumerated power to whatever the President or Congress put in the budget. You must read proposed amendments and understand how they change the Constitution before you support them. Don't go by the names of the amendments. Those names are chosen to deceive you. Read the paper on Mark Levin's amendments. His other amendments are just as treacherous. These false friends are deceptive when they say they want amendments to limit the federal government or limit federal spending. Their amendments institutionalize the very abuses they purport to correct, nullify the natural rights of the people, and fundamentally change the constitutional design. Even though our Constitution is not being enforced, it still declares this federal government lawless. The rule of law is still on our side, but not for long if we foolishly allow our Constitution to be replaced. False friends say, we must amend the Constitution because people in Washington don't understand it. Rubbish. Our Constitution is so simple. Alexander Hamilton said, the people are the natural guardians of the Constitution. Hamilton expected the people to be enlightened enough to distinguish between a lawful exercise and an illegal usurpation of power. Federalist Paper number 16, next to the last paragraph. For clauses the Supreme Court perverted, general welfare, interstate commerce, necessary and proper clause, a quick look in the Federalist Papers shows the original intent. We don't need a convention to draft amendments showing what these clauses mean. Just look it up in the Federalist Papers, but I've already done it. It's all on this one sheet of paper, and you can have a copy. 2 applications have been filed in North Carolina. 2 or 3 applications have been filed in North Carolina this year applying for a convention. HJR 48, HB 321, and maybe one other. One of these at least chants the Convention of States mantra that we need a convention to propose amendments to limit the power of the federal government and impose fiscal restraints on the federal government. But once people understand that our Constitution already limits the federal government to the 18 to 21 powers on the list, and our Constitution already restricts Congress's spending to the enumerated powers, they can see how idiotic it is to claim that the remedy for a federal government which ignores the Constitution is to change the Constitution. The sponsors of HJR 48 and HB 321 and the other one have been deceived by the Convention of States people, so go visit them and undeceive them. For 50 years, change agents tried to get an Article 5 convention. We stopped them. So false friends repackaged the push for a convention. They now market it as an issue of states' rights versus the federal government. They say we must amend the Constitution to restore powers the feds have taken from the states. Rubbish. The 10th Amendment says all powers not delegated to the federal government by the Constitution are reserved to the states or the people. What happened to those reserved powers? The states sold them to the federal government. DHS is nationalizing local and state law enforcement. DHS answers to Obama. My state, Tennessee, allows DHS to be involved in issuing driver's licenses. In 2004, the Tennessee legislature passed an act putting the county sheriffs under the control of DHS. The states went along with the DHS-controlled fusion centers. Thanks to the connivance of state governments, Obama is getting a national police force like the East German Stasi. and we are losing local and state control over law enforcement. State governments are forcing children into federal education schemes such as Common Core. They did it for the federal grant money. According to the Pew report, about 33% of North Carolina's revenue is from federal funds. The states don't want to cut federal spending. They don't want to lose their federal funds. Last year, a Tennessee legislator passed an Obamacare nullification bill, but the fiscal note said that if her bill passed, Tennessee would lose $6 billion in federal funds. Well, Tennessee's legislators didn't want to lose all that federal money, so Tennessee is not going to nullify Obamacare. State governments are not victims of federal tyranny. State governments are enthusiastic participants in federal tyranny. We must stop electing people to office who have their hands out for federal money. There's no such thing as something for nothing. With federal money comes federal control.
That's right.
False friends fabricated the crazy claim that our framers said the purpose of amendments is to rein in the feds if they usurp power. Our framers never said that when the feds ignore the Constitution, our remedy is to change the Constitution. One delegate at the convention of 1787, George Mason, objected to Congress controlling the amendment process. So on the last day of deliberation, September the 15th, 1787, the convention method of proposing amendments was added. But since Congress calls the convention, and because of the necessary and proper clause of Article 1, Section 8, last clause, Congress has exclusive authority to organize the convention. George Mason didn't get his way and was one of only 3 delegates who refused to sign the Constitution. Madison writes in his journal entry for September the 17th, 1787, quote, "The Constitution being signed by all the members except Mr. Randolph, Mr. Mason, and Mr. Gerry, who declined giving it the sanction of their names." Yet false friends claim George Mason, one of the 3 dissenters, is the one who called the shots. We must distinguish between defects in the Constitution and the government's refusal to obey the Constitution to which it is subject. There were defects in our Constitution. Slavery. Amendments fix defects. But our problem is a disobedient federal government and disobedient state governments. That calls for different remedies, and our framers spell them out. What our framers who signed the Constitution actually said is amendments remedy defects in the Constitution. That amendment of errors and useful alterations would be suggested by experience, and that useful amendments would address the organization of the government, not the mass of its powers. False friends claim the states will appoint the delegates to a convention, control the delegates with state laws, each state will get 1 vote, and Congress has no power over the convention. The states run the whole show. And they say they know this because former law professor Rob Nadelson says these were the customs followed in conventions during our founding era. And they say Congress will follow these same customs if it calls a convention under Article 5. But we have never had a convention under Article 5, so Nadelson's customs are irrelevant. Furthermore, there is no such thing as a convention of states to propose amendments. At a speech Robert Nadelson gave on September the 16th, 2010, he announced that he was going to stop calling what he wanted a constitutional convention. Henceforth, he would call it, among other things, a convention of states. Here it is, the top of the second page of his speech, his announcement of the new marketing gimmick.
Here.
It's a marketing gimmick to make people believe that there is such a thing as a convention controlled by states to propose amendments to our Constitution. But the states have no power over the convention provided at Article 5. All they can do is ask Congress to call a convention. Read Article 5 for yourself. Convention of States people are making stuff up. Article 5 says Congress calls a convention. A call is the official summons for the convention to take place. It states the date and location, how delegates will be selected, and so forth. Furthermore, Article 1, Section 8, last clause, the necessary and proper clause, delegates to Congress the power to make the laws to carry out the call. Congress gets its legal research from the Congressional Research Service, the CRS. Here is their April 2014 report on issues under an Article 5 convention. CRS confirms that Article 5 delegates to Congress exclusive authority over both methods of amendment. The report shows that in Congress's preliminary preparations for Article 5 conventions in the past, Congress has provided that delegates would receive immunity from arrest and has planned to apportion delegates the same as in the Electoral College. So California would get 55 delegates, North Carolina would get 15. And Congress decides who will appoint the delegates. Congress may permit states to select them, or Congress may decide that they will appoint the delegates. False friends insist they know exactly how a convention will operate, but page 27 of the CRS report says, quote, in the final analysis, the question, what sort of convention, is not likely to be resolved unless or until the 34-state threshold has been crossed and the convention assembles. You see, the CRS says we'll have to get a convention before we know how it is going to operate. Page 27 of the CRS report, and I'll show you how you can get a copy. False friends say a convention is safe because 3/4 of the states have to ratify whatever comes out. That is not true. If another convention is called, the delegates are the sovereign representatives of the people. They are invested with that inherent sovereign right of the people to alter or abolish their form of government. Declaration of Independence, second paragraph. We've already abolished one constitution and replaced it with another. After July the 4th, 1776, we operated under our first constitution, the Articles of Confederation. That was our constitution until this one was ratified in 1788. This is our second constitution. How did we get from our first constitution to our second constitution? There was a convention to propose amendments to our first constitution. Pursuant to Article 13 of the Articles of Confederation, the Continental Congress resolved on February the 21st, 1787, to call a convention to be held in Philadelphia, quote, for the sole and express purpose of revising the Articles of Confederation, end quote. But the delegates ignored the instructions of the Continental Congress. They ignored the instructions of their states. And they wrote a second constitution. Because of the inherent authority of delegates, it is impossible to stop this from happening at another convention. If we have a convention now, George Washington, James Madison, Ben Franklin, and Alexander Hamilton won't be there to protect you. You don't know who the delegates will be, and you won't find out until it is too late. But they will have the power to impose a new constitution. Now listen well. A third constitution will have its own new mode of ratification, whatever mode ensures approval. Our first constitution required all 13 states to ratify amendments, but our second constitution, drafted at the Amendments Convention of 1787, provided at Article 7 that it would require only 9 states for ratification. 13 states needed to ratify amendments to our first constitution, but only 9 states needed to ratify our second constitution. If we have a convention today, there is nothing to stop the delegates from proposing a third constitution with its own new method of ratification. New constitutions are already prepared and waiting for a convention. Here are 3. The Ford and Rockefeller Foundations produced the Constitution for the new states of America. It is ratified by a referendum called by the President. The states are dissolved and replaced by regional governments answerable to the new national government. Read the new state's constitution and tremble for your country.
Hear, hear.
The Revolutionary Communist Party, USA, has a constitution for the new socialist republic in North America. The Constitution 2020 movement is funded by George Soros and supported by Marxist law professors Cass Sunstein and Eric Holder. They want a Marxist constitution in place by the year 2020. False friends and George Soros and his gang of Marxists have the same goal: a convention so they can get rid of this pesky constitution and impose a third constitution.
Hear, hear.
Michael Ferris may believe that he will write the new constitution. We don't know whose constitution we will get, but George Soros has the money to bribe the delegates. So whether Congress or the states organize a convention is not the critical issue, because in either case, the delegates, whoever selects them, are vested with that inherent sovereign right to throw off this Constitution and propose a third Constitution with a new mode of ratification. The new mode of ratification can be anything: majority vote in Congress, signature of the President, or, as with the new state's Constitution, a referendum called by the President. Look behind the curtain false friends have been put up. Progressives have been trying for 50 years to get a new constitution. That's why they have been pushing for an Article 5 convention, because the only way they can get rid of this constitution and replace it with their constitution is to get a convention. And that is the hidden agenda behind this push for a convention. A new constitution can only be introduced at a convention.
Hear, hear.
Wise men have warned against an Article 5 convention. Here are 3. James Madison, father of our Constitution, said in his November 1788 letter to Turberville that he trembled at the prospect of a convention And if there were an Article 5 convention, the most violent partisans and individuals of insidious views would strive to be delegates and would have a dangerous opportunity of sapping the very foundations of the fabric of our country.
Hear, hear.
In Federalist Paper number 49, Madison warned against an Article 5 convention to correct breaches of the federal Constitution. He said the legislators who caused the problem would get themselves seats at the convention and would be in a position to control the outcome of a convention. Former U.S. Supreme Court Justice Arthur Goldberg said in his September 14, 1986 op-ed in the Miami Herald, he reminded us that at the convention of 1787, the delegates ignored their instructions from the Continental Congress and instead of proposing amendments to the Articles of Confederation, wrote a new constitution. And respecting an Article 5 convention today, Justice Goldberg said, any attempt at limiting the agenda would almost certainly be unenforceable. Former U.S. Supreme Court Chief Justice Warren Burger said in his June 1988 letter to Phyllis Schlafly, there is no effective way to limit or muzzle the actions of a constitutional convention. After a convention is convened, it will be too late to stop the convention if we don't like its agenda. A new convention could plunge our nation into constitutional confusion and confrontation at every turn. Yet, false friends dismiss these warnings as fear-mongering. Are there violent partisans and individuals of insidious views among us today? Yes, and they want a convention. But false friends assure us that only moral and wise people will be delegates. Let's look at that ridiculous claim. There are 3 ways to select delegates. Congress. Does anyone trust Congress to select only moral and wise people as delegates?
No.
State legislatures. Does anyone trust state legislatures to appoint only moral and wise people as delegates?
No.
Popular election. Does anyone trust the people to select only moral and wise people as delegates? After all, we have done such a great job in electing presidents, members of Congress, and to our state legislatures.
Hear, hear. No.
This is the most corrupt period in our history. Lying, oath-breaking, baby-killing, responsibility-shirking are everywhere. And Americans have been so dumbed down they will fall for anything and anybody. Now, our framers advised 2 remedies for federal usurpations. The first is elect faithful representatives. James Madison said, our Constitution depends on the people having the virtue and intelligence to select men of virtue and wisdom to office. In Federalist Paper number 44, Madison said, when Congress usurps powers and the executive and judiciary branches go along with it, a remedy must be obtained from the people who can, by the election of more faithful representatives, annul the acts of the usurpers. But we keep electing politicians who know nothing about our Constitution.
Hear, hear.
Someone cool or cute says something we like and we're all for him. We make no inquiry into his knowledge of these. We destroyed our country because we elected ignorant phonies to office.
Hear, hear.
We must vet candidates candidates for office conduct forums where you test candidates on their knowledge of these. But you must learn it before you can grill candidates. But this is high school level material. You cannot be ignorant and free. The second remedy is resistance. Our framers said the federal government is our creature and must obey our will as enshrined in this Constitution. Alexander Hamilton said in Federalist number 28, last 5 paragraphs, I'm condensing. If the representatives of the people betray their constituents, there is no recourse left but in the exertion of that original right of self-defense, which is paramount to all positive forms of government, and which, against the usurpations of the national rulers, may be exerted by state governments, which will afford complete security against invasions of the public liberty by the national authority. Hamilton says in Federalist number 33, 5th paragraph, if the federal government should overpass the just bounds of its authority and make a tyrannical use of its powers, the people, whose creature it is, must appeal to the standard they have formed and take such measures to redress the injury done to the Constitution as the exigency may suggest and prudence justify. Thomas Jefferson said in his draft of the Kentucky Resolutions of 1798 under the 8th Resolution, where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy, that every state has a natural right in cases not within the compact to nullify of their own authority all assumptions of power by others within their limits, that without this right they would be under the dominion absolute and unlimited of whosoever might exercise this right of judgment for them. James Madison commented on this in his Notes on Nullification written 1834. Quote, the right of nullification meant by Mr. Jefferson is the natural right which all admit to be a remedy against insupportable oppression. End quote.
Hear, hear.
Note, they all said nullification is a natural right. It is not a mere constitutional right. Rights don't come from the Constitution. Rights come from God.
Hear, hear.
In Madison's report of 1799 on the Virginia resolutions, he said under his discussion of the 3rd resolution, I'm condensing, the states in their sovereign capacity are the parties to the constitutional compact and are thus the final authority on whether the federal government has violated the Constitution. There can be no tribunal above the authority of the states to decide whether the compact made by them has been violated by the federal government. That if, when the federal government usurps power, the states don't stop the usurpation and thereby preserve the Constitution, there would be no relief from usurped power. This would subvert the rights of the people and betray the fundamental principle of our founding, that the judicial branch is as likely to usurp as the other 2 branches. Thus, the sovereign states have as much right to judge the usurpations of the judicial branch as the legislative and executive branches. That all 3 branches of the federal government obtain their delegated powers from the Constitution, and they may not annul the authority of the states. And if the judicial branch connives with other branches in usurping power, our Constitution will be destroyed. So the judicial branch does not have final say as to the rights of the parties to the constitutional compact. Otherwise, the delegation of judicial power would annul the authority delegating it, and the concurrence of the judicial branch with the other branches in usurping power would subvert the Constitution forever. In Federalist Paper number 46, that's an important paper, 46, Madison says, respecting federal usurpations, the people can refuse to cooperate with federal officers. State officials can oppose the feds. State legislatures can invent legislative devices to impede and obstruct the federal government in its unconstitutional schemes. States can cooperate in concerted plans of resistance. States can easily defeat the federal government's scheme of usurpation, and as a last resort, the states must defend themselves from the feds. That is why the people are armed.
Here, here, here.
So Jefferson, Hamilton, and Madison tell us, when the feds ask states to do things which aren't on the list, the proper response is no. The 10th Amendment Center says 200 bills have been filed this year in state legislatures to nullify unconstitutional acts of the federal government. Here are some. To allow terminally ill people access to experimental drugs and medical treatments despite FDA rules. Drugs and medical treatments not on the list. Deny resources and assistance to the National Security Agency. Spying on us is not on the list, and the Fourth Amendment didn't stop them from spying on us. Nullify federal bans on growing hemp and marijuana. Agriculture and drugs not on the list. An Indiana legislator filed a bill to nullify all federal EPA regulations. Environmental protection, not on the list. It's so easy. It's either on the list or it's not on the list. You don't need a law degree.
Here, here.
Brave citizens are finding their spines. Rosa Parks and Martin Luther King showed us spine 50 years ago when they nullified the state and local Jim Crow laws by refusing to obey. Recently in Connecticut, citizens refused to obey an unconstitutional state law which pretends to require them to register their firearms. Article 1, Section 15, Connecticut Constitution says, quote, every citizen has a right to keep and bear arms in defense of himself and the state, end quote. If you are a citizen, you have the right to bear arms. That's all you need in Connecticut. So a Connecticut statute making it a felony to possess guns which are not registered is unconstitutional as in violation of Article 1, Section 15 of the state constitution. And the people of Connecticut, as the creators of the Connecticut state government, are the ones to ultimately decide. Disarming the American people. If Congress by law, or the President by executive order, or the BATF by rule, or the Supreme Court by opinion, or the federal government by UN treaty, orders the people to turn in our arms, we must refuse to comply. The Constitution doesn't authorize the federal government to disarm us. Gun control is not on the list. So the states and the people must nullify such law or order or rule or treaty or opinion by refusing to obey.
Here, here.
Yet nullification is under constant attack from false friends who dishonestly or ignorantly claim our framers opposed it. Why do they tell lies about nullification? Because they want you to believe that an Article 5 convention is the only way out. So it's up to us. We must man up, throw off the indoctrination, learn our founding documents, educate our countrymen, trust no one to tell you the truth. You have to look it up for yourself, and repudiate cowardice as the proper response to evil.
Here, here.
Do not let the light we lit in 1776 and 1787 be put out by men of insidious views who plot to get rid of our Constitution and replace it with their Constitution from hell.
Amen.
On my handout sheet, I've got contact information. Contact me, and I will give you the hyperlinks to all of my exhibits. See if I told you the truth. I'll also be publishing a list of the exhibits. Thank you so much for your attention.